Texas Attorney General Ken Paxton has issued a landmark legal opinion declaring that corporate diversity, equity, and inclusion programs may be illegal under state and federal law. This presentation breaks down what Paxton actually said, the legal basis for his opinion, key Supreme Court cases, and practical compliance steps for companies operating in Texas. As stated on the official website of the Texas Attorney General at texasattorneygeneral.gov, the full opinion is available for public review. Let us begin. What does Attorney General Paxton's opinion actually say? Issued on January 15, 2026, it concludes that corporate DEI initiatives may violate Chapter 21 of the Texas Labor Code when they involve differential treatment based on race. On May 12, 2026, Paxton escalated by sending a letter to CVS Health, targeting its supplier diversity program that set aside contracts for minority-owned and women-owned businesses. That letter threatened a fraud investigation under the Texas Deceptive Trade Practices Act and the Federal False Claims Act. According to Law 360, Paxton stated his office would stand firmly against what he called racist DEI policies. The opinion focuses on hiring quotas, race-based scholarships, segregated training, and supplier diversity programs with racial set-asides. Importantly, the opinion does not ban all DEI. Race-neutral initiatives remain permissible. To understand Paxton's opinion, we need the legal framework. Two primary regimes govern employment discrimination in Texas. The first is Title VII of the Civil Rights Act of 1964, codified at 42 United States Code Section 2000E-2-A. It applies to employers with 15 or more employees and prohibits discrimination based on race, color, religion, sex, or national origin. The second is the Texas Commission on Human Rights Act, Chapter 21 of the Texas Labor Code. It mirrors Title VII, but applies to employers with as few as 4 employees. Both recognize disparate treatment and disparate impact theories of liability. As Texas courts established in Quantum Chemical v. Tonys, 47 Southwest 3D 473 from 2001, the TCHRA is interpreted consistently with federal Title VII. Title VII jurisprudence has evolved through decades of Supreme Court decisions. In 1971, Griggs v. Duke Power Company, 401 United States 424, established the disparate impact theory. Practices that disproportionately exclude protected groups violate Title VII even without intentional discrimination. In 2009, Ricci v. DeStefano, 557 United States 557, held that an employer may not discard neutral test results solely to avoid racial disparate impact without a strong basis and evidence. Then in 2023, Students for Fair Admissions v. Harvard, 600 United States 181, ended race-conscious affirmative action. Chief Justice Roberts wrote, "Eliminating racial discrimination means eliminating all of it." This reasoning is now cited in Title VII, Challenges to Corporate DEI Programs. Let us dive deeper into the Texas Commission on Human Rights Act, the statute at the heart of Paxton's opinion. Section 21.051 makes it unlawful to fail or refuse to hire, discharge, or discriminate in any other manner against an individual because of race, color, disability, religion, sex, national origin, or age. Section 21.101 specifically prohibits segregating or classifying employees in a way that deprives any individual of employment opportunities. Paxton argues that DEI programs limiting participation by race constitute discrimination under Section 21.051 and segregation under Section 21.101. The TCHRA provides remedies including back pay, reinstatement, compensatory damages, and punitive damages capped under Section 21.2585, plus attorney's fees. Two monumental Supreme Court decisions in 2023 reshaped the legal landscape for race-conscious programs. First, Students for Fair Admissions v. Harvard, 600 United States 181, held that race-based affirmative action in college admissions violates the Equal Protection Clause. Second, 303 Creative LLC v. Ellenis, 600 United States 570, held that the First Amendment protects individuals from being compelled to create expressive content that violates their beliefs, impacting mandatory DEI pledges. Paxton's opinion explicitly cites SFFA's reasoning that race-based decision-making is inherently suspect and must survive strict scrutiny, a standard few corporate DEI programs can meet. Since SFFA, multiple lawsuits have been filed challenging corporate DEI under Title VII and Section 1981 of the United States Code. The SFFA decision has triggered cascading legal challenges to corporate DEI programs. government enforcement actions, and corporate retreats from diversity commitments. The EEOC has opened investigations into corporate DEI programs that appear to discriminate based on race, mirroring Paxton's analysis under Title VII. Major corporations including Meta, Google, Amazon, McDonald's, Walmart, JP Morgan Chase, and John Deere have scaled back race-based DEI hiring targets and supplier diversity quotas. Texas Senate Bill 17 from 2023 banned DEI offices at public universities, a model replicated in Florida, North Carolina, and Idaho. Shareholder derivative lawsuits have challenged corporate DEI as breaches of fiduciary duty, arguing these programs create legal liability. Texas has been at the forefront of the anti-DEI movement, but this is part of a larger national trend. Beyond Paxton's opinion, Texas passed Senate Bill 17 in 2023 banning DEI at public universities, and House Bill 3979 restricting critical race theory in schools. The multi-state anti-DEI coalition includes Florida with its Stop Woke Act, Alabama, Kentucky, Mississippi, Tennessee, Arkansas, Louisiana, and West Virginia. At the federal level, Executive Order 14398 from March 26, 2026, banned racially discriminatory DEI activities for all federal contractors, enforced by the DOL Office of Federal Contract Compliance Programs. However, some states like California, New York, Washington, and Illinois mandate diversity programs, creating a compliance minefield for multi-state employers. For companies operating in Texas, here are 5 essential compliance steps. 1. Audit all DEI programs for race-based criteria, including hiring targets, scholarships, training, and supplier diversity programs. Replace them with race-neutral alternatives based on socioeconomic background or geographic diversity. 2. Open all programs to all employees to avoid Section 21.101 segregation claims. 3. Review TCHRA compliance. The Texas Labor Code applies to employers with just 4 or more employees, broader than Title VII's 15-employee threshold. 4. For multi-state companies, document your compliance rationale in each jurisdiction. 5. Consult legal counsel. This area of law is evolving rapidly.